The judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Morning, everybody. Welcome to the United States Court of Appeals for the Fourth Circuit. We're honored to be with you this morning here at the law school. Seated. We have three cases on for argument this morning. First up is United States versus Davis. Counsel, whenever you're ready.
May it please the court. My name is Robert Wagner. I represent the appellant in this case, Mr. Richard Davis. I want to point out that Mr. Davis is actually here. He's in the back of the courtroom. He has completed his sentence with the Bureau of Prisons, wheelchair in the back, and he wanted to be here to make sure that justice is served in his case. He asks that his convictions be reversed. Judge, we present four issues before the court today, and I'd like to begin with the issue identified by the court in its description of the case. And that's the issue of knowledge, of whether the district court erroneously found that the appellant, Mr. Davis, knowingly committed healthcare fraud offenses. Now, from the opening brief, Mr. Davis made clear that, according to the United States Supreme Court, a person acts knowingly if they act with knowledge of the facts that constitute the offense. That's Dixon versus United States. This court, in United States v. Moody, a 2021 case, also identified knowingly as merely requiring proof of knowledge of the facts that constitute the offense.
So can I ask you about that, Mr. Wagner? Are you,
Sure.
with respect to that element of knowledge, is it your position that Mr. Davis needed to know every minutia of every one of the incidences that the United States alleged constituted fraudulent claims? Or, as I think the government would frame it, he simply needed to have initiated, put the wheels in motion to allow the specific offenses to happen? He didn't need to have knowledge of each and every element of each of the separate counts. Which one is it?
Well, Judge, that he had specific knowledge.
Of what?
Of the claims that were submitted. That's the
Each
standard.
individual county needed to know that each healthcare professional on a particular day committed a fraudulent act?
That's correct, Judge. I think that's the standard that has been articulated by the 10th and 11th circuits that we asked this court to adopt, but it's also the standard that the government itself established in the indictment. In the indictment, the government said, as Mr. Davis well knew, these claims were false, these claims were fraudulent.
Well, I guess their position is that he well knew that he had brought to fruition a scheme that would have led to the billing of false claims against the government. That's what I understand their position to be.
Well, I understand that position, Judge, but we've also attacked the scheme or artifice to defraud. We've laid out in our briefing that in this particular case, you've got a situation where the people who are providing the services, the counselors, were providing at least 5 hours a day of reimbursable services. You heard from just about every witness in the case.
Isn't that a factual question for the district court?
It is, Judge, but certainly this court reviews the factual determinations of the district court.
Why do you say that there's a mens rea is absent here? It seemed to me that that the case bottomed out on whether he knew that he was billing Medicaid for services that fell short in two respects. One, that the services were never provided, were never undertaken, that they just weren't performed. And the other was that he was misbilling for things like planning, which were not reimbursable. So either one of two things. Number one, that the services were never provided, and he was billing for services that were never provided. And in addition, the services that were provided were not reimbursable, but they were still reported nonetheless. And if he knew that he was doing these things, which essentially was ripping off the Medicaid program, how can you possibly contend that there was no mens rea here? Because it seems to me that's, pretty much garden variety fraud. And if you know that you're essentially lying to the government and seeking money and seeking reimbursements for something you never once did. And why isn't this really, we can talk about specific intent and this and that and try to get all wound up about those things, but it comes down to a basic point. He was billing the government for something, to reimburse him for something that he'd never performed and something that was not reimbursable. And so why is there a mens rea problem here?
Judge, I think this comes down to some very foundational points that we've raised in our briefing, that we raised before the district court. The foundational points are first and foremost as to the scheme or artifice to defraud, which I was trying to explain before, that each of these counselors testified at trial that they provided at least 5 hours a day of reimbursable services.
Well, but aren't we under a clearly erroneous standard with respect to those are factual findings as to whether the two witnesses, Bill and Larry, the question is to whether they were credible and who thought what. Isn't that all factual for the district court to address? That's not the province of the Court of Appeals.
The records, I believe, speak for themselves, Judge. The records show that these hours were reported, and then the witnesses themselves never claimed for each of them. You talk about Ms. Loney.
So, but you're asking us, aren't you asking us to say the district court erred in finding Bell and Loney to be incredible witnesses when the district court heard them and we haven't? I mean, there's got to be it's a bench trial. It's true, but deference belongs to a bench trial the same way it would belong to a jury trial. And there seems to, I would think that in the assessment of the credibility of Bell and Loney, as to whether they were telling the truth, as to whether they were credible witnesses, their testimony is very damaging to you. Very damaging. We can go in each to the problems with your view as to each of these two key witnesses. But the point I'm making is that we have a district judge here who listened to these people, and the case seemed to me to rise and fall on the testimony of Bell and Loney. And we have a district court that listened to them both and made factual findings and credibility assessments. And we're up here, and those two witnesses are nowhere to be found in this room. And I don't understand why. We can try to make it complicated, but I don't understand why at its core there's not a certain simplicity to it.
Judge, I believe that we have in fact satisfied the clearly erroneous standard. And I would take issue with the court's comments that these witnesses testified that they didn't perform the required hours here.
And to follow up on that very point and to follow up on Judge Wilkinson's good questions. So there were 6 counts, right, that were alleged against your client.
Yes, Your Honor.
He was acquitted of 4 of them.
That's correct.
Convicted of 2.
Yes, sir.
And the 2 counts dealt with 2 very specific dates, April the 30th, 2018, May the 9th, 2018.
Yes, sir.
And so, there's a lot of atmospherics in this case about group billing and all other kinds of shenanigans. But the key question is, did the government present sufficient evidence to prove beyond a reasonable doubt that on those 2 dates, these counselors falsely billed Medicaid beyond the 3 units that they were authorized to bill?
Right.
And frankly, I have a hard time finding in the record evidence that those counselors testified to those facts, that they actually billed erroneously, falsely on those 2 dates. Isn't that what this case is about?
If I'm understanding your question correctly, I don't believe either of those witnesses testified.
I mean, they suggested that there were all kinds of shenanigans going on, and that generally, as a matter of fact, they were directed to bill in excess of what Medicaid would have allowed as a general principle, and that's concerning. But the question is, did the government prove beyond a reasonable doubt that on these 2 dates, these counselors filed fraudulent bills? And that's a question for your colleague on the other side. But
right, no, I appreciate that, Judge.
I have a difficult time seeing in this record where that evidence is.
Well, we did too, and we.
Well, can we start with count 3?
I'm sorry.
Can we start with count 3?
Certainly, Judge.
Sure, that's the one involving Cassie Loney.
Yes, sir.
Don't her progress notes that day indicate that time was spent on planning and no indication that it was spent on something that's reimbursable? Why isn't that sufficient evidence on count 3?
I'm sorry. So are you asking?
The progress notes don't indicate that she spent any reimbursable time on the date covered by count 3. Why isn't that sufficient evidence that she didn't do any reimbursable time on that date?
My reading of the record is that she said she spent a considerable amount of time with counseling of the client on that particular.
What
day.
if I read the record as saying that she admitted that not what she testified, what her progress notes say?
Yes.
That her progress notes do not indicate that she spent any reimbursable time on the date covered by count 3. And I know maybe she testified to something different, but in terms of sufficiency, why isn't it pretty damning evidence that your contemporaneous records of what you did that day don't indicate that you spent any time doing anything reimbursable that day? Again, maybe a fact finder could come up with a reason why there's an explanation. But in terms of sufficiency, why couldn't a fact finder say the best evidence of what you did that day is your notes of what you did that day?
So there was a lot of testimony at trial over whether
a fact finder doesn't have to believe any of it.
But if I could judge, just that there was a lot of testimony at trial that the progress notes were not kept contemporaneously.
Great. These are great arguments why the fact finder shouldn't infer from the fact that the progress notes don't mention anything. But that's not a sufficiency argument. That's an argument that you make to a fact finder.
And also there was testimony at trial that the progress notes were not necessarily reflective of the time.
And again, these are great defense arguments at trial. I'm just not sure they work in a sufficiency context. The fact that there are other explanations that a jury or a fact finder could have accepted. I mean, on sufficiency, we assume every single time there's a disagreement between you and the government, they believe the government and disagree with you. That's how sufficiency review works, right?
Correct.
Okay, so why is that not enough?
Because I believe this court needs to look to the testimony of the witness and the testimony of the witness as to what the witness did on that particular day. And the evidence from the case is that she testified consistently that she provided at least 2 hours of planning each day.
Well, but hold on. But that's the other problem. Your brief again and again talks about people's testimony about what they normally do, what they typically do, what they do most of the days. But when it comes to 3 and 4, it's not about what people normally do or mostly do. It's what they did on that day. So again, on a sufficiency standard, I don't know how testimony about what someone normally does has much to do in a sufficiency challenge.
I understand your question, Judge. I understand your concern, but it is the government's burden to prove beyond a reasonable doubt that those services were not provided on those particular.
Okay.
Why wouldn't they? The government have proved that, because the testimony from Bell, for example, was that, and here's someone who is a full-time elementary school teacher, and she simply didn't have time, in the view of the district court, in the middle of the school day to devote to her second job of helping Mr. Davis. And the testimony, as I understand it, was that she was given standing instructions that were to apply. It didn't matter what day. That the customary thing was you just bill 2 hours in the middle of the day, no matter what, regardless. And this was the modus operandi of the operation, that that they were to bill those 2 hours as a matter of sort of standard practice. It wasn't some days you provide them, other days you don't provide them. It was an across the board instruction from this gentleman to the employees that we just, as a matter of course, bill these 2 hours in the middle of the day. And it is just awkward to see how a full-time elementary school teacher who's, who works pretty much of a full-time day could ever have sort of just taken off in the middle of the day and worked her second job, and that and the district court found her to be credible. And then you have Mr. Looney, who was told to bill midday hours when no children were even present. And that's not a reimbursable expense. And the point is, these instructions to Bill and Loney were not time dependent. They weren't dependent on a particular day. They were across the board. This is what we do. This is our practice. And why isn't the blanket instruction, to follow up on Judge Hyten's view, why isn't that sufficient?
Well, for Ms. Bell, Your Honor, who was a full-time school teacher, as I've indicated in my briefs, as the record shows, she made clear to Mr. Davis that she was going to perform the necessary hours. And let's turn to the date in question that Ms. Bell was concerned with. In her particular situation, she was tasked with billing 5 hours a day. Her progress note on that day said 4 hours of counseling. And then she said that she would regularly get in care coordination of approximately 1 hour each day. That's the 5 hours, Judge. She met the 5 hours under the testimony that was provided at trial, under the records, the progress notes that were provided to DMAS for reimbursement. And so the government simply failed on that particular count. Now, you mentioned Ms. Loney as well, Judge. On Ms. Loney's count, you have a situation where she didn't specifically testify about anything that happened on that day. And that's where the government fell short.
I know you're about, can I ask you a question about willfully? The willfulness requirement. We haven't talked about that aspect of mens rea.
That's right. I know. I'm out of time.
Chief, can I ask?
Absolutely.
So let's posit that I think you're right, that the district court fundamentally misunderstood how willfulness works. Because I think
fundamentally
misunderstood how willfulness works. Let's posit that I think you're right about that. I'm not saying I do, but posit for this question that I do. What I don't know what to do is with the district court's alternative finding on JA 398, when the court says, first of all, I conclude the defendant is wrong about willfulness. Let's posit that I agree with you that the court's wrong up until that point. But then the court very clearly says, even if I adopted the defendant's definition of willfulness, I would still find it as satisfied. What do I do with that?
No, and I understand the court's concern, and it's a legitimate concern. But the point I try to raise here, Judge, is that the government, in presenting its case through its indictment, through its trial brief to the court, outlined these issues and did so erroneously. So the judge is predisposed to find in a certain way, to decide in a certain way, and the lens through which.
So I'm not supposed to believe the district judge when they say, even if I applied your standard, I'd still find your client guilty. I'm supposed to assume the district court is not telling the truth when they say that?
No, but it did so in hindsight. It applied as it was listening to the evidence in the case, as it was assessing what it was hearing throughout the trial, it was viewing that evidence through the lens that the government doesn't need to prove by a specific intent. And so that's what we're focused on here, Judge. And so after the fact, in hindsight, yeah, well, even if that was the standard, that the government's met that standard.
All right, thank you, Mr. White. Thank you. We'll hear from the government.
morning, Your Honors. May it please the court.
I see you wore the right tie.
I did, Your Honor. In a brief moment, in a personal dispensation, I sat in this room 15 years ago for a very similar argument that had no concept that I would be back here. So I'm very gratified to be here. My name is Shay Gibbons, and I proudly represent the United States of America. Richard Davis was the owner, CEO, and clinical director of Innovative Family Services. In this role, he signed an enrollment agreement with Medicaid that he would follow the rules. He would follow federal and state law. And despite these Medicaid rules that prohibited billing for transportation, group care coordination and planning, and documentation of medical records, he instructed his employees to bill for 2 hours in the middle of the day, no matter what they did. That's fraud, and it violates the
Well,
Medicare
it's not
requirements.
actually fraud until they actually bill for time they didn't actually do, right?
Yes,
I mean,
Your Honor.
maybe you're a bad person if you tell people to do things, but until someone actually does it, it's not fraud, right?
That's correct, Your Honor. Yes. I'd like to first talk about counts 3 and counts 4 and why those are problematic.
But am I reading the record correctly that these were standard instructions that were not dependent on what happened here or there, that they were instructions to do this regardless?
Yes, Your Honor. That is very clear from the record.
But that is, I mean, is that the critical question here as to whether we go at this bill by bill, day by day, and take every single billing in order to have a sufficient evidence for any particular bill? We have to go every time a bill is submitted. We have to prove beyond a reasonable doubt. Or is it sufficient simply to say this was a fraudulent scheme and we're not just puffing smoke on that? We've got the evidence for that in the testimony of Bell and Loney that this was a scheme and it was not dependent on any particular day. It wasn't particular on any day because the standard instructions were to do this every day. And the question is that adequate, sufficient in a case of Medicaid fraud? But isn't that the question here?
Your Honor, I think there are multiple layers to that. So ultimately, the question is, are counts 3 and 4 proved beyond a reasonable doubt?
And those counts are related to a specific date.
Yes, Your Honor.
And the government did not allege or charge a conspiracy in this case, right?
Yes, we did not believe that any of the
So
subordinate
that's why it is
employees.
important to focus on the dates and
Yes.
not this open, related to Judge Hyten's point, that it may be bad form to say, do this regardless. But if in fact the reality was that on those 2 dates, notwithstanding those fairly sinister instructions, the counselors in fact complied with their requirements under the law, there's no offense, right?
Yes, Your Honor, I
Okay,
agree.
so can we take count 4?
Yes, I would love to start with count 4. That's our
So can
strongest
we,
argument.
okay, so just, I want to make sure they billed for 3 units, right?
That's correct.
That means someone has to have worked at least 5 hours.
Yes.
You agree there is pretty substantial evidence that she billed at least 4 hours?
I do not agree, Your Honor,
No?
because
The progress notes indicate there were 4 qualifying hours that day, right?
that particular progress note, yes.
Okay. So if that were credited, so I'll give you a chance to explain why we
Yes.
don't have to credit that, but if we were to credit that, then she needs 1 more hour, right?
Yes.
Once we hit 5, we're fine. You can bill 3 units.
Yes.
Okay, so what's the evidence that the 2 hour, so, and I believe they claimed 2 hours of planning,
Yes.
and then the witness on the stand admits that she didn't do 2 hours of planning.
That's correct.
Where's the evidence she didn't, but she doesn't need 2, she needs 1. Where's the evidence she didn't do 1?
Well, a couple of things. If you look at the record, JA 1820. So we put into the record 3 other progress notes for 3 other recipients on that specific day, where she claimed that same 2-hour period, which she didn't have because she was a public school teacher, to 4 separate clients. So if you just take that hour a day that the defendant claims happened, and you spread that 4 different ways, that's only.
Yeah, but maybe she's group, but again, this is the chief's point, like, fine, maybe there was fraud about those other people, but we're talking about this count for this one. It could be that she was group billing for the same amount of time for 4 people, and maybe that's okay, maybe it's not okay, but if she actually did it. So, okay, so what again is the evidence? Because again, it doesn't matter that she didn't do 2, right? Because claiming to do 6 when you really did 5 doesn't matter, because if you actually did 5, you can bill 3 units.
Yes.
Okay, so
That's
what's the
correct.
evidence she didn't do one?
So she didn't do one because she split whatever time she devoted to innovative work on that particular day. She split between at least 4 different people. And she also said that she engaged in non-reimbursable activities, such as documentation of medical
On that
records.
date?
On that, well, not specifically on
Well,
that
that's the
date, but during
problem,
that
right? I
time.
mean, the whole point is the government has the burden to show what happened on that date.
And this court's decision in, I'm not going to say this right, but Bajogli, it's a 2015 case, it highlights that in a scheme and artifice to defraud case, such as 1347, it shares similar elements to a conspiracy, that instances of a healthcare fraud scheme charged as part of a scheme and artifice. For example, it's not 404B evidence to talk about other manifestations of a healthcare fraud scheme outside of those charged in the indictment.
Is there any evidence anywhere in this entire record? I mean, I'm well aware that the government has the ultimate burden of proving beyond a reasonable doubt, but you have a trial, you have, even with that burden of proof, you still have evidence coming out on both sides. And is there any specific evidence that she actually, that Bell actually did perform 2 hours of work on the 2 days in question?
There is no evidence that Ms. Bell did any particular work for Innovative during that midday period. And we're not talking about the after-school period where actual services were rendered.
Why doesn't that get that backwards? Don't you have to show, the government have to show that she didn't perform 2 hours of work?
The way I specialize in healthcare fraud, and the way these typically work is that
I'm just thinking of criminal law 101. This is like standard defense counsel opening statement and closing argument rhetoric. I don't have to prove a single thing. I don't have to say a single thing. The assumption is that what my client has done is legal unless and until the government proves that it's not legal, right? This is standard defense counsel rhetoric, which also happens to be legally accurate. So, right,
Yes.
for the chief's point, why does she have to prove that she did bill? Wasn't it your obligation to prove that she didn't?
And here's where we get back to the scheme and artifice.
Can you answer that? Is that right?
That,
Judge Heitens, is he correct?
well, he's correct, yes. The point is that the scheme and artifice, and specifically getting back to Judge Wilkinson's point, the uniformity of the instructions to bill for this time, no matter what, makes the regular practice more and more relevant to what happened specifically on May 9th, 2018 for count 4 and April 2018.
It seems like you're arguing like this is propensity evidence. It might have happened on some other dates that are irrelevant to the count. And so we ought to infer from that criminal misconduct occurred on this date.
I don't believe it's propensity evidence. Again, going back to the Bajogli case and the scheme and artifice, that there's a scheme and artifice that enforces the same standards every single day. This isn't a case where there was some variation in how these 2 hours were billed. These 2 hours were billed for every single employee, every single day.
Absolutely. We'll grant you that. But then the question is, were those 2 hours that were billed on that date, did that amount to fraud because the hours actually weren't worked?
Well, and then we get to the sufficiency review and the standard. With all inferences in favor of the government, the fact finder hearing all of this evidence ruled that 5 hours of services weren't rendered because Ms. Bell was a school teacher and could not have performed these midday hours to the extent claimed.
But it doesn't shift the burden of proof, does it? Of course, the government has the burden of proof, but then they're shifting responsibilities. And the Title VII case is a classic example, even though it's a civil case. But they're shifting responsibilities within that ultimate burden of proof, and that doesn't result in nullifying or the government's burden ultimately to prove the crime beyond a reasonable doubt. The government did put on the evidence that these were standard instructions, and as a matter of common sense, it would be at least to the defense's advantage to put in evidence, say, well, they may have been standard instructions, but they really weren't at all. And here are instances where where she has testified, yes, I actually worked. I took time off from the school. I went off and performed these 2 hours of work. Somewhere in this entire record, one would expect it to take cognizance of the fact that it is to the defendant's advantage to say, well, you may have these standard instructions, but they're not standard at all. And on this particular day, she actually performed the work. And if that's the case, then we get into a day by day, closer to a day by day analysis. But was that kind of testimony ever put on that on this day, on any day, did she testify that she came in and performed 2 hours of work?
She did not testify to that. She said that to the extent she had time in her school day to perform any work for her second job.
But all I would have taken was some testimony that just, well, there, occasionally we did come in and perform that work. And I know that, notwithstanding, there were days when we came in and we performed those work. But that's not there in this record, is it?
Both Ms. Loney and Ms. Bell testify about their normal practice and the practical import of these healthcare fraud cases with thousands or tens of thousands of false claims or particular.
But you're not answering my question. I'm asking you whether there was testimony in the record that she actually did on some days come in and perform the 2 hours of work.
There's no evidence one way or the other, because she doesn't remember this particular.
Okay, so you have the standard instruction and it's not contradicted, right?
Yes, Your Honor. And then she has a consistent practice. Ms. Bell and Ms. Loney have consistent
You have
practices.
the consistent practice, and you would expect some testimony as to variance from the specific practice, and it doesn't shift the burden of proof to note that the defendant can put on to his own advantage, significant advantage, that there was some variation somewhere, one day out there when somebody came in and performed the 2 hours of work. And then we move from the systemic perspective into a day by day perspective. But there wasn't, as I read the record, this was a standard invariable practice. And I don't see that was put into dispute.
Yes, Your Honor. So we believe, to put a point on this, that the district court justifiably relied on evidence both of consistent instructions from Mr. Davis and consistent practices by Ms. Loney and Ms. Bell to prove that on April 30th, 2018 and on May 9th, 2018, that they did not perform these services as described in the medical record.
So can I take you to the willfulness question?
Yes.
Okay, so I want to do the opposite with you that I did with your colleague. I'm aware that the district court said, even if I followed his standard, I would still convict. And I think that's a serious problem for them. It seems to me, having read Brian again this morning, that the district court was fundamentally deeply confused about what willfulness means. And I don't understand that. And would you like to try to convince me why the district court wasn't? Brian literally says, and when used in criminal statutes, willfulness means knowledge that your conduct is unlawful or a bad purpose. And then the district court goes on a whole little digression that says sometimes willfulness does not mean what Brian versus United States says very clearly was what willfulness means in criminal statutes.
Well, if you look right under that section, there's a footnote.
Yeah, the footnote that says sometimes it's construed to mean this, but the district court then extrapolates that to say that in criminal cases, it can mean all those things, except if you look above the line in Brian, they say again and again and again and again, in federal criminal statutes, willfulness means bad purpose or knowledge of illegality. Am I right that that's what Brian says over and over again is what willfulness means?
Yes, Your Honor. And I will say that this court in RSM and in Blankenship has used footnote 12 language in criminal cases to say that it's not just a bad purpose. It's not limited to a bad purpose.
That strikes me as an extremely bizarre reading of what Brian says.
The footnote.
I don't read that footnote as saying that's how we do criminal. The footnote is appended to a sentence where Justice Stevens says, like, willfulness, it can be used to mean a lot of things. Footnote. Here's some of the things that willfulness has been used to mean. But above the line, he says, in federal criminal statutes, the thing that willfulness means is knowledge of illegality or bad purpose, right?
Yes, and that's exactly what Brian says above the line. And this court, and again, in RSM Inc. and Blankenship.
Well, then the district court, we've also read Brian to say what Brian says, and then the district court seems to think that it doesn't have to follow what we've said because it thinks it's inconsistent with Brian. That was also, to me, a very confusing footnote in the district court's opinion.
This has been an open question. There's certainly a lot of ambiguity as to how this court and other courts, and the Singh decision from the Sixth Circuit is emblematic of this, that the willful jury instructions and the understanding of what willfulness means in criminal statutes, specifically in 1347, is not clear.
You know, you got all these words flowing around: specific intent, willfulness, purpose. Of all of those words that are sort of floating around as to the mens rea, what do you think it's as to the mens rea? What state of mind did the district court's decision rest upon? Did it rest upon willfulness, purpose, knowledge? What was it?
It was willfulness. In terms of the definition of willfulness, the district court said he acted with a bad purpose, consistent with.
Well, that was its alternative finding. Its first finding was that he was reckless, he was super negligent, and let's posit that I don't think that any of those are willful.
And that's fine. That doesn't change the result in this case. The government's recommendation to this court is to follow the Sixth Circuit's decision in Singh and apply Bryan, above the line language or below the line language, and clarify that it means a bad purpose or knowledge that a person is acting unlawfully.
What do you understand so overall, Bryan says knowledge that you're violating the law. I agree it says bad purpose a few times, but the thing that it primarily says is that the classic definition of willful in a federal criminal statute is that you have to know that what you're doing is illegal. You don't necessarily have to know what statute you're violating, and I think the amendment to this statute makes clear. You don't have to know that you're violating this provision of the Medicaid Act, but you do have to know that what you're doing is illegal, right?
Yes.
What do you understand the relationship between knowledge of illegality and bad purpose? I guess I will say that part of Bryan confuses me a little bit because I don't understand the relationship between those two things.
Certainly, Your Honor. In addressing these issues, I feel there's a large amount of ambiguity between the definition of knowingly and willfully. So knowingly, when we get to the Dixon case and understanding the facts of the case, understanding what is going on, whether this is intentional conduct or accidental conduct, we believe that the defendant's proffered standard of knowing the minutia of every claim and thousands of healthcare fraud claims is just ludicrous. He set up the scheme, and in fact, Ms. Bell testified that he was reviewing progress notes. He was in the loop. So regardless of the standard applied, knowingly satisfied.
Is it sufficient that you simply know the facts? In other words, is it sufficient that in a case of fraudulent misconduct that you simply know the facts underlying the fraud? You know that you bill for services that were not reimbursable. You know that you bill for services that were never performed. And if you know that, the statute requires the finding of knowledge or willfulness, as I understand it. But if you know that you billed for services not performed or that were not reimbursement, why isn't that sufficient in mens rea terms? I mean, you know, we can have the angels dancing on the head of a pin here, and we can get into specific intent and the rest. But if you know, not necessarily what the law is, but if you know, which is the mens rea, what the facts were, if you know what you did, and that's what the law requires. And this person, he knew what he did. He knew that what he was billing. He knew he was misrepresenting things. And we're saying, well, there was a problem with mens rea here, but there's not a problem if you know that you're committing fraud.
Do you agree with me? This statute doesn't say knowingly or willfully.
Yes,
it says
Your Honor.
knowingly and willfully.
Yes.
Okay.
So we believe knowing the facts of what you're doing, intentional versus accidental conduct, that's knowingly. Let me talk briefly about willfully. The defendant's proffered standard is that you have to use the word fraud in instructing your subordinates to do things. And if you don't use the word fraud, you haven't acted willfully. That's my reading of the defendant's position. And that just simply cannot be the case. He certainly didn't use the word fraud. There's no evidence that he said, we're going to do fraud together. Let's commit fraud. But his actions in being under an obligation to follow the rules and telling employees to bill 2 hours no matter what.
The Medicaid program, it's just the expenses are increasing by leaps and bounds and fraud in Medicaid reporting is absolutely rampant. It's an endemic problem, Medicaid fraud. I have some sympathy for people who are trying to figure out these Medicaid regulations because they're so, they're Byzantine in the extreme. It takes me a long time to figure them out, and if I ever do, and it would seem to me that this gentleman would, that anybody would have a hard time figuring out sometimes when the Medicaid. But what is this a case for civil sanctions? You chose to go the criminal route. Would an alternative path have been available to you, where you would just seek return of funds or some kind of civil remedy here? Why does this case fall on the criminal side of the ledger rather than on the civil side? Because you do have the option of bringing a civil action.
Your Honor, I see I'm out of time. May I respond?
Absolutely.
Yes, certainly there are civil and administrative options that could have been pursued. And the reason why this is a criminal case was the instruction to bill 2 hours no matter what, and the instruction to bill for transportation, documentation, group care coordination, and group planning. If this was a reasoned decision and a good faith interpretation of the Medicaid rules, we wouldn't see instructions to bill for things that are plainly prohibited. And that's why he was convicted of counts 3 and 4. And that's why his conviction should be affirmed.
Couldn't somebody get confused about whether planning, for example, was reimbursable? You have this quilt work of some kinds of expenses that were reimbursable and others were not. Clearly, when no services are performed, that those are not reimbursable. But where some services are performed, it's a closer question sometimes as to what's reimbursable and what's not. And part of the confusion here maybe was whether planning exercises were reimbursed.
So the defendant would love for this case to be only about group planning. Group planning must be acceptable for these claims to be permissible. But we can win even if we show that he billed for group care coordination, which everyone agrees is not allowed, transportation, and documentation. So if you look at just those plainly impermissible things, there's still evidence in the record to show that counts 3 and 4 were fraudulent and false.
All right, thank you.
Thank you, Your Honor.
There are 3 things I'd like to address in my time that's reserved for rebuttal. First is about the scheme or artifice to defraud. And as Judge Heitens, you pointed out, as long as we can show 5 hours of reimbursable services for the 3 units that were billed to Medicaid, then there is no fraud here. Witnesses testified as to that 5-hour threshold through Ms. Bell, Joint Appendix 577, Ms. Carter, Joint Appendix 665, Ms. Loney, Joint Appendix 749, Ms. Mazix, 783, Mr. Martin, 1231. All of these witnesses provided testimony to the court that it was the practice of the counselors at this particular place, at IFS, that you have at least 2 hours of planning and at least 3 hours of counseling for each of the students, for each of the patients involved. Second, the government wants this court to impose liability and culpability on Mr. Davis for every specific count in this case, for every specific claim that was submitted for reimbursement to DMAS. Well, if they really wanted that, they could have charged this as a conspiracy, and they didn't. And finally, Mr. Davis, there's been a lot of talk about what he instructed to people to do and what his modus operandi was for this business. Let's be clear, he never instructed any employee to commit fraud, never instructed any employee to submit a
Wait,
fraudulent
hold on, but
claim.
write down 2 hours a day, no matter what. At least, again, from a sufficiency perspective, I don't know why a fact finder can't infer whether you actually work 2 hours or not, write down 2 hours. That is at least a permissible interpretation of the statement. Write down 2 hours, no matter what. Isn't it at least permissible interpretation of that?
Judge, I understand the concern there, but
No, that's a direct question. Do you think that's a permissible, at least a if I were to say to you every single day, write down 2 hours, no matter what, do you think it is a permissible interpretation of what I've just told you that I said, even if you didn't actually do 2 hours, write down 2 hours?
clearly the way that is phrased, that is not permissible. And I concede that point, but the question is, to what extent did he really mean? I mean, there are bosses out there who tell their employees to max bill. And that was another term that's been used in this case, maximum billing. And I know in law firms, there are a lot of folks, partners who are telling their associates to max bill. It doesn't make it fraudulent. I think that there was some hyperbole.
I understand your position, Mr. Wagner. And in fact, there was evidence, I think, from Ms. Bell that I believe they asked her what would have happened if Mr. Davis had found out that you were actually billing time for which you were not being compensated. And she said she would have been fired. But given you that, what is wrong with a fact finder crediting Judge Hyten's version of the evidence? I mean, you've conceded that would be improper or unlawful. So what was wrong with Judge Gibney going with that theory of the case?
Well, because the evidence, at least on the two specific counts, didn't bear that out. There wasn't proof that those 2 hours were not performed, at least by Ms. Loney, and that in the case of Ms. Bell, that 1 hour was not performed, the 1 hour that was required to reach the 5-hour threshold. I see my time is up.
All right, thank you. Oh, you have a question?
No, I'm good.
Okay.
I'm fine.
Thank you, Mr. Wagner.
Thank you.
Sure, we can do whatever you like. I'm fine.
All right, thank you, Mr. Wagner. We'll come down and greet you and then move on to our second case.
Thank you. How are you? You're home here. I didn't have to travel.
Our second case is 22-4576 US v. Blackman. Counsel, whenever you're ready.
May it please the court, Tiffany McGregor on behalf of Mr. Blackman. This appeal presents a single issue, whether the government has proven beyond a reasonable doubt that the Erlanger error in this case was harmless. It has not. Because the government failed to carry its burden, this court should remand for resentencing without the armed career criminal enhancement.
Can I ask you about that? Why isn't that flat out inconsistent with Brown? I don't understand. Let's assume for the sake of argument you win, both as a matter of first principles, but also as literally a matter of what this court said in Brown. The remedy is to vacate his guilty plea, not to give him the benefit of a sentence free of the ACCA enhancement, right?
Your Honor,
We said this quite clearly in Brown. Brown was also a guilty plea case, and we said if the defendant wins, the remedy is to vacate the guilty plea, not to just resentence him.
well, Your Honor, I believe that in this case that I'm sorry. Your
So one way to think about this, you agree with me that this indictment actually charged the ACA enhancement, right?
It did, Your Honor.
This indictment actually said his prior offenses occurred on occasions different from each other. That was in the indictment.
I agree with that, Your Honor.
And you agree that your client pleaded guilty to that indictment.
He did plead
So
guilty.
at this point, absent some defect in his plea colloquy, he has pleaded guilty to an indictment that charges the ACA enhancement. So I don't understand how any error other than maybe a Rule 11 plea. Now, let's posit that given Erlinger, the district court said something to him at the plea colloquy that was totally wrong.
Correct.
But that's a Rule 11 plea colloquy error.
It is, Your Honor.
So why isn't the remedy to vacate the plea, not to give him the benefit of an offense he wasn't charged with?
Your Honor, I believe because he pled guilty to possession of a firearm by.
No, he pled guilty to an indictment that charged possession with a firearm while being subject to the ACA enhancement. That's the indictment he pleaded guilty to.
Your Honor, I do not believe he made that admission during his
It doesn't-
plea.
Right. So again, maybe the district court erred in accepting his guilty plea because the district court accepted a guilty plea in which the defendant did not, in fact, admit everything in the indictment. But
Correct.
that's a plea error, right?
That is a plea error.
In other words, if the district court had correctly at the guilty plea stage said, and if you go to trial, you can have a jury trial right on the ACA enhancement, and then he pleaded guilty, we wouldn't be here, right?
Correct.
So it's a plea. Okay. So again, I don't understand how the remedy, in addition to what we said in Brown, I don't understand how the remedy for an error during the plea colloquy is to give the defendant a better sentence based on a crime that was not the crime charged in the indictment.
Well, Your Honor, that may be the case. It may be that the correct remedy is to vacate back to allowing Mr. Blackman to decide whether he would continue to plead guilty.
I mean, isn't that part of the analysis that the defendant would not have pled guilty had he been properly advised of the law and what the possible consequences were?
That is the proper analysis.
Okay. So why isn't it true in this case that there's no possibility that your client would have taken a different route, given the fact that the offenses, at least to me, the ACA enhancement offenses appear clearly to have occurred on separate occasions, and that the risk of being proven wrong were just too significant for your client to take a different route here?
Well, Your Honor, it would be our position that the sentencing disparity would have created a powerful incentive for Mr. Blackman to have the government carry its burden to prove his predicates occurred on different occasions.
Maybe you can elucidate me as to what arguments you would have made before a jury that would have persuaded a jury that these offenses, these three, were they robbery offenses?
A robbery offense, Your Honor, I believe, an assault, breaking and entering.
That these did not occur on different dates. I mean, what's the argument?
Well, Your Honor, I believe it's not Mr. Blackman's burden to prove that he.
You're right about that. In fact, we had a big argument about that earlier. So, but on the face of these, the allegations, assuming a rational, reasonable jury, what would be the argument? Just indulge me. What would be the argument as to why the jury would be persuaded that those did not occur on a separate occasion?
Well, Your Honor, I could proffer any argument, but ultimately it's the government's burden to prove that had Mr. Blackman been properly advised, that it was their burden to prove.
But you could have made that
occasion's
exact.
issue.
Okay, but the one thing I know for sure is that alone isn't enough. And the reason I know that is because in Brown, this court held that in a similar case, the error was harmless. And everything you just said would have applied in Brown too. So maybe another way to ask the Chief's question is, this case is different from Brown because. Complete the sentence. This case is different from Brown because.
I would say this case is different from Brown because Mr. Blackman, first, there was a sentencing disparity of, if he had won on the ACA issue, his guideline range would have been much lower and his statutory range would have been lower. That created a significant incentive for him to make the government carry their burden.
That's always going to be
versus just admitting, I'm agreeing to spend the next 15 years.
Right. But that's always going to be the case in a situation like this. I guess you're saying that it was so significant a disparity that he would have been willing to roll the dice on.
He may have been, Your Honor.
But
And
that's-
it's the analysis here is, would he have waived that right beyond a reasonable
Well, one of the
doubt?
things that the Supreme Court's decision in Greer says we should look at is the revealed preferences of the defendant. The case about the forfeited Rahafe heirs. And the court said, look, after a person gets a sentence they're unhappy with, they have a lot of incentive to say, if I'd known this was coming, I never would have done it. And so we are allowed to be a little bit skeptical of things that people claim they would have done after the fact. And so one of the things that Rahafe says is that Greer says we should look at any evidence of the defendant's intent before he knew how things were going to turn out. Did Mr. Blackman ever seek to withdraw his guilty plea before the district court?
Your Honor, he did not seek to withdraw.
Why isn't
his
that a
guilty
pretty,
plea.
even after the district court said, even after the district court said, I'm going to make these findings and I'm going to give you the ACCA enhancement. At no point he said, whoa, that is not the deal I agreed with. I want to withdraw my guilty plea. He didn't ever do that.
No, he didn't. But I'm not sure that at his plea colloquy, the court said, I'm going to apply.
Do you really want to vacate this plea?
Your Honor,
I mean, is it in the interest of your client to have this plea vacated?
Your Honor, Mr. Blackman would then have an opportunity to determine if he wants to admit that ACCA.
Well, what are you asking from us?
Your Honor, I'm asking you to find that the error was not harmless.
To do what?
To find that the error was not harmless.
Well, but where do we go from there?
Your Honor, based on this record, we don't know that the government has competent trial evidence to prove all the ACCA predicates.
Well, can I ask you another harmlessness question? Your client, as I recall, did not object to any of the factual statements in the PSR, right?
He did not.
And the district court, without objection from the parties, adopted the factual statements in the PSR, right?
It did.
And once that's true, so that means that for purposes of this record, your client did not admit anything about what the PSR said about the temporal relationship between these prior offenses, right? Okay. Of all the cases you've looked at, what is the longest gap between two separate criminal offenses have you ever seen a court say was not the same, was not different occasions? The longest.
In the cases that I've looked at recently. Maybe months.
Okay, and how far are these apart?
These are years apart.
Have you ever seen a court ever say things that happened years apart weren't multiple occasions?
I have never seen a court do that,
Okay.
Your Honor.
Why should we?
But the question here is what a jury.
Why should we rule in your favor if we don't know what you want? And it would seem to me you got the benefit of a 3-point reduction in the offense level by virtue of acceptance of responsibility, and you go back before the district court and go to trial, and given the significant mountain of evidence against you, you're probably in all likelihood going to be convicted. And then when you go back and go back to sentencing, you're not going to have the benefit of the acceptance of responsibility reduction in the offense level. And normally when someone comes before us on a guilty plea, they say we want the guilty plea vacated, but you haven't said that. Do you want this guilty plea vacated? Or because it would, just looking at the evidence against this gentleman, this is not the kind of case that someone would want to take before a jury. It just, it's just, it's a sure loser. And what do you want us to do? Because why should we be wrestling with this and ruling in your favor if you're not sure you even want the guilty plea vacated?
Your Honor, I believe that Mr. Blackman is entitled to have the proper his rights advised to him, and to make a decision based on that understanding, to make a decision based on whatever evidence the government may
But if
proffer.
the standard is one of a reasonable probability that he would not have pled guilty, given what he knows about the Supreme Court's decision in Wooten and Erlinger, how can we find a reasonable probability that he would not have pled guilty if the threshold question and you can't even tell us here that you're contending he would not have pled guilty.
Your Honor,
You're not even making that argument.
Your Honor, I don't think that the question is whether he would have not pled guilty or whether he would have pled guilty. The question is, can the government prove that he would not have? And that's not for Mr. Blackman to prove, that's for the government to prove. And on this record, considering that he may have, first of all, there's no competent trial evidence to say that they could have presented to a jury on these predicates. And then second, the fact that if he won, he would have potentially saved 12 years of freedom that they can't say beyond a reasonable doubt.
Well, can I just ask you, so let me posit first, the government 100% forfeited this argument, but I don't actually understand why this is a preserved claim at all, because if you posit, as I think is right, the error is in the advice that the district court gave him at the plea colloquy. The defense counsel didn't object during the plea colloquy. I mean, I think the government had a serious argument that this Erlinger error is forfeited because there was no objection at the plea colloquy to say, excuse me, Your Honor, you have just told my client something that's legally wrong. I object. And there was no such objection at the plea colloquy, was there?
No, there wasn't.
Okay. But again, I think but I mean, you said like in terms of whose burden this is, right? I mean, because I assume that the government's argument on the other side is going to be like, yeah, the reason the record has no evidence of what our evidence would have been at trial is because he pleaded guilty. And one of the things that we get when defendants plead guilty is that we don't have to fully prep our trial. That's like one of the benefits the government is buying when it does a guilty plea. So I could imagine the government saying, it's a little bit unfair to say the record doesn't show what we would have shown at trial because the defendant pleaded guilty.
That's correct. It does not show that, Your Honor. But
Can I follow up on Judge Heidens' question about what the defense preserved or not, or the government, I'm sorry, preserved or not? And you can correct me if I'm wrong, but I understood that the government took the position that enhancement should not apply in this case, notwithstanding the state of the law. Do I have that right?
that is correct.
So it's kind of a bizarre situation.
The government did take that position, and knowingly taking that position, they did not offer anything that would have, for the record, that would have established these predicates.
Right. And so from the defense counsel's perspective, they were quite content, I think, with that position, right? They didn't have to say anything on top of that.
No, the defense counsel did not take anything other than to preserve the issue.
Okay, so the other thing is you've made an affirmative statement that there's no competent evidence to make out these ACCA enhancement offenses, but how do you know that? Are you just
Well, there's nothing in this record.
Right, but we don't know what the government could present or put to the test, right?
We do not. And that's exactly why we say that they can't meet their burden beyond a reasonable doubt that Mr. Blackman would have still pleaded guilty or admitted the occasions issue.
Well, I guess, go ahead, I'm sorry.
I was going to say, the presumption of finality that attaches to guilty pleas, and it's a very, very strong presumption. And it's your burden to, I think, because the Supreme Court's established a very high bar that there has to be a reasonable probability. The standard isn't written in terms of a reasonable possibility. The standard is even higher, that there has to be a reasonable probability you would have not have pled guilty. If you had known of the Supreme Court's decision and given the years separated the predicate crimes in this case, it seems to me that the chances of prevailing on an Erlinger claim or a Wooden claim are between 0 and none. And so how can that meet the reasonable probability standard that you would not have pled guilty when there's language in the Supreme Court's opinion saying that, I mean, in that case, the crimes were committed on the same evening. But here you have years separating the predicate offenses. And then you have the additional factor that all of these brutal acts were committed against 3 different victims. There were 3 women who were assaulted and brutally treated. And so why should there be any vacation of a guilty plea in light of the distance that separated the predicate crimes, in light of the Supreme Court's language, in light of the fact that it might have been disadvantageous, significantly so, to take this case before a jury? I don't understand. There's so much that makes vacating the guilty plea problematic, not just for one reason, but for 3 or 4.
Your Honor, I see that I'm out of time. Can I
You
respond?
may answer.
Thank you. Your Honor, I believe that in this instance, Mr. Blackman, had he been given the opportunity to have this case, to have the occasions issue presented to him where he understood that he had the right to a jury trial and had the opportunity to evaluate the government's evidence based on that constitutional right. There may not have been any evidence. One of the
No, but
crimes-
everybody, everybody sits in a jail cell and that they get a case of buyer's remorse and say, gee, if I'd taken my case before jury, they would have convicted me, they would have acquitted me. And so you have these people who face long terms in prison having a case of buyer's remorse and saying, gee, I wish I'd rolled the dice in front of a jury and everything. But if we recognize that as a basis for unwinding a guilty plea to which a presumption of finality attaches, we'd be litigating and relitigating and relitigating guilty pleas, and the burden imposed upon the system, and in this case with no apparent benefit to the defendant, the consequences of that would be pretty serious.
That would be pretty serious. However, I do believe this case would be different than a buyer's remorse, because in this case, Mr. Blackman was not advised of his right to a jury trial on this issue. And those cases, I believe the court is, I'm sorry, that you're speaking of, Judge Wilkinson, those are cases where someone was fully advised of all of their rights and chose to forego a jury trial on that issue and pled guilty. So if we were before this court speaking about Mr. Blackman's choice to plead guilty to the possession of the firearm by a felon only, I would say that this would be a buyer's
Well, that's the whole
remorse
point.
situation.
When the whole point of the Supreme Court's decision presupposes that someone was not advised of their rights on this particular thing, but the Supreme Court says, the question is whether it's harmless error.
Correct. And then we would submit in this situation, it's not.
All right, thank you, Ms. McGregor.
Thank you.
Hear from the government.
Good morning. May it please the court. Julie Niemeyer for the United States. The standard that my friend is advocating for is essentially the standard of structural error. But that's not the standard that this court must apply. We already know, because of the Brown decision, that the question here is whether the Erlanger error was harmless. And to answer that question, we have to think about this hypothetical.
Before we get too deep into this, can I just ask you something that's been troubling me about this case? Why did it take more than a year after the defendant's arrest to indict him? When I was reading the timeline of this case, there's like more than literally a year between his arrest and indictment date, and I didn't understand why that was the case.
I'm sorry, Your Honor, I can't answer that. I just don't know.
Okay.
So in this case, we have to look at this hypothetical question. What would have happened in the district court if Mr. Blackman had been properly advised that he had the right to a jury finding beyond a reasonable doubt on this issue of whether his past offenses were on different occasions?
So we basically take the plea colloquy and where the district court says, that I'll determine if the ACCA enhancement applies at sentencing. If the court had said instead, you would have a right to a jury's decision about whether that's the hypo where we change the plea colloquy to saying that.
Exactly, Your Honor. And so facing that question, what would Mr. Blackman have done knowing that his 3 prior violent felonies were 5 years and 7 years apart? Would he have rolled the dice and let a jury decide that question, knowing that when he lost, he would then face a higher guidelines range?
And he would no longer have acceptance of responsibility, and a variety of other negative sentencing consequences would follow.
Exactly, Your Honor. Or would he have made the rational choice to waive that jury right and to preserve the benefits of his guilty plea and thus have a much lower guidelines range? The evidence here in this record shows beyond a reasonable doubt that he would have made the latter choice. And because of that, that was the only way to reduce his sentence. And so we know that this error did not affect his plea. It did not affect his substantial rights, and therefore it should be disregarded.
Can I ask you about, I think Judge Heitens mentioned this to your colleague, that wasn't the government's position at trial, right? And so we've got a different view now of the ACCA enhancement and whether or not it should apply. So is there a forfeiture problem here for the government?
Well, Your Honor, of course, it is a very unusual situation where
I'll say.
the government articulated a new litigating position after the Wood case.
Unfortunately, that's not so unusual anymore, but go ahead. I'm sorry.
Right, Your Honor. The government formulated this new position because the Wooden case essentially changed the standard. Instead of simply looking at the fact of a prior conviction, the Wooden case instructed us that we had to look at this panoply of factors. We had to conduct a holistic review of the timing and the nature and the quality.
And then you have a concurrence from the justice that ends up writing Erlinger saying, wow, if we're doing all that, that sure sounds like an Apprendi question, right?
Exactly, Your Honor. And so what Wooden did is essentially lay the groundwork for the Erlinger court to realize that this took that fact-finding process beyond what Almendarez-Torres permitted the sentencing judge to do. And so recognizing that, government articulated that position at Mr. Blackman's sentencing.
Well, the Wooden case really sets out a blueprint that's sort of on all fours with this particular case, because it says in a situation where all of the crimes are committed on, on a single evening and the homes or whatever are close together and everything, then that's likely not to be harmless. But where you have a situation, and this is right out of the Supreme Court decision, you have a situation where the crimes are separated by years and by locale and with different victims. They said there's no way that could be anything but harmless. And that's this case, and the Supreme Court has just already answered it in terms that could not be clearer.
Yes, Your Honor, absolutely.
So is the government's position essentially the only way that a jury could possibly have found these were separate? The only way the jury could have possibly found him guilty of the underlying substantive offense, but then concluded the ACCA enhancement didn't apply. That's the hypothetical that a jury does, right? They find him guilty of the substantive offense, but they conclude the ACCA enhancement doesn't apply. Is the government's position that essentially the only way the jury could do that would be jury nullification, because under the correct legal standard, there would be no bait? Now, but you agree, juries are, I guess I won't use the allowed word, juries have the power to nullify. But I guess then would you further then say that like Brown and Greer say the possibility that a jury might nullify is not enough to render the error not harmless?
Exactly, Your Honor. I think it's helpful to go back to the whole rationale behind the doctrine of harmless error in the constitutional context. In Brown, this court said, discrete defects in the criminal process, even if they represent a constitutional error, are not structural because they do not necessarily render a criminal trial fundamentally unfair or an unreliable vehicle for determining guilt or innocence. And this court was quoting the Greer standard when it said that in Brown. So the whole philosophy of this doctrine is that there are these errors that don't make the process fundamentally unfair to the defendant.
And an error is not harmless just because it's possible that if this error didn't occur, the jury might have done something different. Like
Right.
possible in the sense of like you could imagine it happening. Right. That's not
Exactly.
enough to make an error not harmless.
Exactly. And fortunately, we're not without a roadmap in conducting this analysis. This court has looked at this precise question 7 times since Brown and Boggs were released. And in each of those 7 cases, which were unpublished decisions, the court found that the error was harmless beyond a reasonable doubt. And in doing so, the court identified 4 primary indicators that help that analysis. So I'll just list them briefly, and then I'll go back to each one.
These are in Brown, or are these in these unpublished opinions?
I'm sorry, sir.
These 4 things are in Brown, or they're in these 7 unpublished opinions?
The factors are discussed in Brown,
Okay.
Your Honor, but they're identified more clearly in the unpublished decisions as an analysis.
Okay.
So first, was the defendant properly advised that the armed career penalty could apply? When so advised, did he ever seek to withdraw his plea? Did the defendant dispute the accuracy of any of the information in the PSR that was underlying the enhancement? And then finally, what essentially were the odds of success for the defendant? And in 7 of these cases of the court has recognized what it calls an inverse relationship, essentially, on that 4th factor between the strength of the evidence supporting the enhancement and the likelihood that the defendant would give up the benefit of his guilty plea in order to try to fight that.
Sorry, repeat these again. Whether he's advised of the ACA, whether he seeks to withdraw his plea. The third is what? I'm sorry?
Did he object or dispute the accuracy of
the PSR. Okay.
the PSR?
Wait, then why isn't that obviously missing at least one factor, which is like, what's the ups? So number 4 in some ways is like, what's the downside from his perspective? Why wouldn't you obviously also ask what's the upside? Because, right, the bigger the potential benefit, the more, this is just like micro econ 101, right? I would weigh like, what's the best thing that could happen and what are the odds of that? And what's the worst thing that could happen? What's the odds of that? So it seems like to me, a rational defendant would think, well, like, I mean, if I would be radically better off if I won this argument, right? This is why like homicide defendants go to trial sometimes, because the disparity between what you get if you're found guilty versus if you're not is so big. Even if the odds are low, it's worth sometimes taking a risk if you're going to get a huge benefit, right?
Right, I understand, Your Honor.
Okay.
I think that inquiry is baked into the 4th factor.
Okay.
It's baked into this question of the odds, because the inverse relationship between the evidence and then what the defendant decides, that assumes that the defendant is doing a calculus with the assistance of his counsel, of course. And the calculus is, what are my chances of winning on this evidence? What do I have to gain if I contest the enhancement? What do I have to lose? That's all part of that same analysis. So in this case, going back to the first factor, of course, the defendant, Mr. Blackman, was properly advised that he could face the ACA penalty. It was in his indictment. His indictment not only charged a violation of 924E, but it also specified that he had committed these 3 violent felonies on different occasions.
And it's cited the ACA.
I'm sorry.
The indictment also cites the ACA.
Correct, sir. Yes, yes.
But the whole inquiry requires us to look backward at the time that the plea is taken. If the full information was there, it's a backward glance. It is not a glance of what the prisoner is thinking in his prison cell. That is not the relevant. That is decidedly not the relevant question. The relevant question is the calculus that would have been made given what we know about the evidence and given what we know about the strength of the case and all of the rest. And the question is, on that date, had he been informed of Erlinger and Wooden, what would he have done? But it's not what he's thinking now. What he's thinking now is not relevant. What he was thinking or would have been thinking then, had he known, that's the only question.
Exactly, Your Honor. And when we look at what was he thinking then, we know that he was thinking, yes, there was this possibility of the ACCA penalty, and he was told that. The only thing he wasn't told was that the burden of proof would be higher.
And no, and judge versus jury.
And judge versus jury.
Which,
yes.
I mean, Erlinger makes very clear that the judge versus jury distinction is critically important under, right, okay.
Absolutely, Your Honor.
As
But
is the burden, it seems to me. You just pointed out something that seems to be critically important. There's a amount of difference between proof by preponderance and proof beyond a reasonable doubt. And a particular defendant might, notwithstanding the long odds given the evidence, might say, well, the jury might be the conscience of the community and might decide that in my particular case, it's just not the proper result that I should face this enhancement. What's wrong with that analysis?
well, that's a very true analysis, sir. But I think that kind of takes us to the third factor of the court's analysis on harmless error, which is, was there any dispute about the facts that underlie this enhancement? And here there just simply was not. And that is what would be going through the defendant's mind and the defendant's counsel's mind as they were facing both the Rule 11 and the sentencing. They'd be thinking, having been properly advised, how strong is this evidence? That would be part of.
Well, as you, I think you began your argument with it. If these facts, with the separation of these offenses, suffice to vacate the plea, then there's no such thing as harmless error, because you're not going to get another case where you have the different victims, the different locations, the increased time span between the things, between the crimes. And if this suffices to vacate the plea in this instance, then there is no longer a harmless error doctrine, and we have essentially nullified the Supreme Court's views in Wooden and adopted what is in essence an approach of structural error to the occasions matter. And that is not where the Supreme Court is, and that is not what this record shows.
Exactly, Your Honor. 100% agree with that. And that goes back to the standard that was referenced in Greer and in Brown, that these errors do not represent a fundamental unfairness to the defendant.
Well, hold on, but I admit I'm the person who introduced both Greer, but Greer, it is pretty important, is it not, that Greer is a plain error case, not a harmless error case?
Absolutely, Your Honor.
Because, for example, seriously undermine the fairness, integrity, and public reputation of judicial proceedings is a critically important question in a plain error case, and it is literally not a question in a harmless error case, right?
Of course, but
Okay.
we're talking here about the effect on substantial rights.
Okay.
And of course, the government accepts that burden, but the government has met that burden here because it has shown that based on the facts here, the evidence here, the record shows this would not have had an effect on his substantial rights.
So I realize this is kind of fighting against Brown, which I realize is ironic given that I was on the panel in Brown. But it seems like that's a kind of weird way to do harmless error, because it essentially says, dear defendant, prove to me that you would have done something different. And like, that's not normally how harmless error works generally, right?
Yeah, I would agree with that, sir. But kind of similar to the Greer context, again, we have to look at the whole record, and the government is looking at the whole record. The court is looking at the whole record. And of course, it is up to the government to articulate how that record shows an absence of evidence that could.
So without asking you to concede on behalf of the government any specific case. So your argument is that if we accept the defendant's argument, there's no such thing as a harmless Erlinger error in a guilty plea context. I guess you've cited Brown plus 7 cases. I guess the hypothesis on the other side might be the government is articulating a standard where there's literally no such thing as a harmful error in the guilty plea context of Erlinger. So again, without asking you to give away the facts of any specific case, can you walk me through what, in the government's view, the characteristics of the type of a case where the government would lose this harmless error question look like?
Absolutely, Your Honor. I think we can go right back to Brown, because even in Brown, there was this circumstance where two of the defendant's predicates were sentenced on the same day. And so,
like, he maybe has a pretty good argument these are actually different occasions.
of course, there could be a factual argument that the defendant was confused, that the defendant misunderstood that the proceeding was sentencing him on two cases instead of just one. There could be a factual issue there. The timing of the arrests, the convictions, of course, the closeness of the actual offenses. I think
so. So this again, because your take here is that for a jury to find these weren't the same occasions, the jury would essentially have to nullify. So a case where, no, the jury wouldn't have to nullify. The jury would have to adopt a fairly charitable to the defendant view of the facts, but it wouldn't be necessarily nullification for them to find that they're different occasions.
Right. It could be a charitable view. Of course, the defendant.
And that's a kind of case where a defendant might say, well, I'd like to go to a jury and make the government prove beyond a reasonable doubt.
Sure. And perhaps the defendant could put on evidence saying that this is the paperwork that I received when I was sentenced in that consolidated proceeding, and I didn't understand that this was two separate convictions.
No, but I mean, that's the easiest one. But then there's the one where, like, the defendant has a, shall we say, aggressive but plausible argument under Wooden, that even accepting the facts, we all know the facts, like one happened at 11. So I know Wooden says, for example, courts have almost always found things that happen a day apart to be different occasions. But imagine a world in which one of them happens at like 11:45 p.m. and the next one is a robbery that happens the next morning at 9. That
exactly. And I can say, I think safely, I think it's appropriate to say that the government has foregone this enhancement in cases exactly like that. Cases where the timing is too close, where the locations are too close.
Can I ask you a question about what evidence the government would present in a ACCA enhancement mini trial where the evidentiary burden is proof beyond a reasonable doubt? Because Ms. McGregor says that there was no competent evidence in this record to make that case. First of all, do you agree with that? And second, with the evidence, and I guess part of that argument is it's a sentencing proceeding. At the time, it was proved by preponderance. The rules of evidence are relaxed. And so obviously before a jury, you'd have an entirely different presentation or not. What's your view of that?
Oh, of course it would be different, Your Honor, because of course the government would have to put in, let's say, a certified copy of the judgment of each conviction. The government would probably have to call a witness. Which could get under, sorry, just to walk now the chiefs, like now we're in a jury trial, so the rules of evidence apply. That's fine, because those are going to come in as like public record. They're going to come in as public records. Even if it wasn't certified or came in under that exception, a clerk could testify that this was a reliable record from that particular court. And we're not going to be able to rely on the probation officer's description of what the facts of that offense were. The government's going to have to call people or somehow present hearsay from the probation officer is not going to come in about what the circumstances of the previous offense were. Correct, Your Honor. Correct.
So does that at all impact the calculus? I mean, it's more difficult. I mean, how long ago were these offenses?
2003, 2008, and 2015.
You might have some problem finding witnesses to talk about the particular facts of the offenses, particularly the one in 2003.
May not be a fact witness, Your Honor, but there certainly could be a witness to the reliability of the certified conviction. And here, what the PSR shows is not the evidence itself, of course, because this was a guilty plea, but what it shows is earmarks of derivation from Shepard-approved sources. And the court is able to rely on that because it bears those earmarks of reliability.
Juries can't rely on those, right?
Oh, absolutely.
So
No.
One question, just as you close out. So in a post-Erlinger world, is the government doing this? Are we doing this as one trial, or are we in cases that go to trial? Probably there aren't that many, but in cases that go to trial, do you know, does the government currently have a position? Do you have a single unified trial where we do the facts of the underlying crime and we also present evidence of the ACCA enhancement in a single proceeding before a jury, or do we bifurcate, or does it depend?
I see my time has expired. May I respond? I haven't seen one of these proceedings, but I believe the better way to go about it would be a bifurcated proceeding where the jury is asked to look at the substantive nature of the offense. And then if a guilty verdict is reached on those matters, then to proceed to whether the sentence enhancement element has been met beyond a reasonable doubt.
Thank you very much, Ms. Niemeyer.
Thank you.
Mr. McGregor?
Thank you. I'll just point to two things. First, when the difference is potentially 12 years of liberty, we can't say beyond a reasonable doubt that a rational defendant would have surrendered his right to a jury trial and to require the government to prove the ACCA enhancements beyond a reasonable doubt. And then speaking to the evidence that may be presented, especially with the 2003 conviction, that the certified judgments may have the dates of offense or things of that nature, but we know that sometimes those records may not always be accurate exactly to the dates, because there's no reason for the defendant to challenge the date sometimes, and we know that.
Why wasn't that done at the earlier hearing, at the original guilty plea?
Your Honor, I would submit that at the guilty plea hearing, there was no issue about the ACCA, the dates of conviction. That would have been a sentencing issue. Is Judge Wilkinson, are you asking me why didn't he challenge that at the sentencing hearing?
Yeah, I'm asking you, it seemed to me that the guilty plea hearing, the defendant here had counsel, that the PSR was attested to as accurate, that the sentence and the ACC enhancement were fully explained. It seemed to me that there was the things that we like to see in guilty plea hearings were there, and this question of different occasions, the Supreme Court may not have ruled on it, but it was certainly bubbling about the lower federal courts, and if there was an objection of some sort, it would seem to me the counsel would have raised it, but there wasn't. It was PSR was submitted, as I understand it, unobjected to, and as a result, the district court adopted it, and it became part of the record. And I don't think the Supreme Court has indicated that the harmlessness inquiry would turn on a factor such as that the critical questions were the separation in time, and the separation in location and the difference of the victims, and all of the factors and all of the arrows seem to me to make it a problematic case for you. But I mean, I do think that, you know, it would have been always open for you to object to the PSR had you felt the client would have been prejudiced in any way, but there was no objection.
Well, Your Honor, I believe the decision to object to the PSR and the decision to have the government prove that armed career criminal enhancements are two separate inquiries because they're under two separate legal standards.
Can I take you back? The first thing you said in your rebuttal was 12 years. And yeah, 12 years is a really big difference. Do you know what the disparity in Brown was?
Your Honor, I do not recall.
Like, presumably the defendant in Brown also had I not gotten this enhancement, my guidelines range would have been blank. So I was just, okay.
Yes. Thank you.
Thank you, Ms. McGregor. I want to
Thank
thank
you.
both counsel for their arguments. We'll come down and greet you.
Can we take a brief recess?
We'll come down and greet you and take a brief recess before moving on to our third case.
This honorable court will take a brief recess.
Counsel, I'm going to ask you to come on up and give me a fist bump. Thank you so much for your argument. We really appreciate it.
Thank you. Great help.
I can do a little report. A weird setting to do your first.
Thank you so much. We appreciate
Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Judge Heitens predicted that we'd see a few more faces for this third argument, so that's right. As usual, he is correct. All right, our third and final case is 24-1237 Colonial Web Contractors Company versus Hill Phoenix. Counsel, whenever you're ready.
May it please the court, good morning. My name is Robert Lofton from McGuire Woods in Richmond. On behalf of the appellant, Hill Phoenix Incorporated, with me at counsel's table is my colleague, Mr. Dillard. Let me begin by answering the two questions presented in this appeal. First, yes, the district court was wrong. Second, yes, this court has the ability to both review and correct the errors of the district court below.
I guess one of the other implicit questions is it really best practice to file a single notice of removal for two different cases in state court?
Yeah, actually, Judge Heitens, I would say yes, it is.
What in the federal statutes or federal rules of civil procedure allow you to file a single notice of removal for two different cases?
Nothing at all, and nothing prohibits it either.
Sure.
And so here, Mr. Dillard was actually the attorney at McGuire Woods who spoke to the clerk's office in Henrico County. Initially, our client was served one order, a one-page order, which is at Joint Appendix page 116 and 117, allowing the amendment of one of the complaints. We contacted the clerk's office upon receipt of that order. We were told that it appeared that there were two cases opened in error. Under 1446, all we had to attach.
Were both of these cases filed in state court?
Yes, sir. There were two cases that were actually filed in state court. Case number one dealing with the Michigan project, the other with the Colorado.
They were filed as separate cases.
Yes, sir. And initially, what we were told is that there were two cases opened in error because the complaints were substantially the same. They were given two different case numbers, 4146 and 4146.
The contracts were different contracts, weren't they? I mean, they had different forum selection clauses, and they involved sales of refrigerator equipment in different states. One of them was in Colorado, and I guess one was in Michigan and one was in Colorado.
Yes,
so they were filed as two separate states, two separate state court actions.
Yes, sir. They were filed as two separate state court actions, but I would clarify one point in Judge Wilkinson in your statement that they were the terms and conditions that are at issue in the case. They're the same. You know, Hill Phoenix has
I thought the contracts were a bit different, and maybe it was within the. I realized there was a large overlap in the contracts, but I thought maybe there was a difference in the forum selection clauses or what have you.
There is it. So let me clarify my answer, Judge Wilkinson. There is a difference between Hill Phoenix's terms and conditions and Colonial Web's terms and conditions. Hill Phoenix's are at Joint Appendix page 5.
But they were not identical contracts, were they?
Between the two parties, no. Essentially, with the project, yes. And Colonial Web, in its briefing before Judge Hudson, before the district court, essentially said like there are two complaints, but they're essentially the same.
Well, but your removal notice purported to remove both cases. Is that correct?
Yes, sir, it did. The removal notice, it provided, we were very transparent with the clerk's office in the Eastern District.
Aren't there a lot of district court, at least district court cases out there that say it's improper to remove more than one case with a single notice of removal? That you can't have a single notice of removal for multiple cases. you will acknowledge there's a good bit of law out there for that proposition that, one notice of removal, one case, but not one notice of removal, two cases, huh?
Your Honor, I will acknowledge there are some unpublished decisions from federal district courts. The only one that we found in the Fourth Circuit was from Judge Alston, dealing with an attempt to remove multiple criminal cases.
Right, I know, but what concerns me is that there were you had this removal notice, a single removal notice, and that you're removing two cases, and then all of a sudden you say, well, this might be a little shaky to you have this single removal notice for both cases. So maybe we can avoid the whole difficulty by consolidating the two cases. And so you proceeded on your own motion to consolidate the two cases, which did strike me as exceedingly odd, because normally it's the function of a court to decide whether to consolidate cases or not. I think it's odd that a litigant is coming in before us when the litigant is deciding to consolidate or not to consolidate. I thought that was the consolidation was a function of the court, and I wanted to strategically, you were just trying to sidestep those district court decisions that have said it's not proper to remove multiple cases with a single notice of removal, and to sidestep that, you arrogated something unto your own power that was really something for the court to decide. And if I'm correct in my query, isn't that a little bit shaky what happened here?
Judge Wilkinson, I would respectfully say you were not correct in your fundamental hypothesis. We were not trying to sidestep anything. We were very transparent. If you look at the notice of removal.
Well, what authority did you have to consolidate the cases?
Well, one, we did not consolidate the cases.
You mean this is the part where at JA5 you say we request that the court consolidate them?
Yes, we did. So we did not consolidate the cases ourselves. We did ask the court to consolidate the cases. The clerk's office administratively combined them. And Judge Hudson found that that was an error under Rule 42. But there's no precedent from any federal court anywhere in the country finding that a violation of Rule 42 is a defect in the removal process, that one, deprives this court of the ability to review Judge Hudson's decision, and two, renders Judge Hudson's decision correct.
So can we put aside the subject matter jurisdiction for a moment? Because I understand your argument. I tend to think it's a pretty good argument that this is not based on lack of subject matter jurisdiction or colorably characterized. So I'm more interested in the defect in removal procedure.
Yes, sir.
So I want to give you a hypo. So imagine that in their motion to remand, they had specifically asked the district court to do the precise thing the district court did on the precise grounds. I understand your arguments they didn't, that they were talking about the forum selection clause, and I take your point, that's not a defect. Hold that aside. Let's just say they literally said the exact thing the district court said, and not just in the facts section, but in there, what we are asking you to do, Judge, is remand because of this defective consolidation. Do you think that remand order would be based on a defect in the plausibly characterized as a defect in removal procedure?
Or colorably characterized, as the Supreme Court said in Power X. And
I understand I've just asked you to assume a whole bunch of things you don't think are true, but let's
I welcome that hypothetical. Okay. I think that hypothetical is Quackenbush. And the Supreme Court of the United States in Quackenbush in 1996 made clear that an abstention-based decision ordering remand was reviewable by the circuit.
Wait, that's not abstention based. It would be that again, I actually find, as a person who used to teach Civ Pro, I actually find it quite surprising that I also am not aware of a statute or rule that answers the question of whether you're allowed to do this, a single notice of removal. But what if the district court said, look, there are these weird gaps in the procedural rules, and it's my belief that you're not allowed to have a single notice of removal cover multiple state court actions remanded. Is that colorably characterized as a defect in the removal procedure?
No, I don't think so.
Really? Because it sounds like a statement of you're not allowed to remove cases this way, so I'm remanding it. That sounds like a defect in removal procedure. Now, again, maybe the district court's wrong about that. Maybe you're in fact allowed to do that. But
well, I think the question for this court, and this is where I do think Quackenbush is helpful, because the Supreme Court made clear, I mean, like the district court there relied on Burford abstention, remanded the case back, it went up. As you're well aware, and the Supreme Court said, no, that is reviewable. And under your hypothetical, I don't think that could be colorably characterized.
Oh, I agree in that case. In the same way in Thermatron, where there the district court's like, I've got other stuff to do. And the court's like, that's not a defect in removal procedure.
Right. And I think in doing the colorable characterization analysis that you're required to do under your hypothetical, there's no basis in the statute to support the conclusion that,
both of these cases are they're state court cases. I mean, they're state law cases. They're both breach of contract questions. I didn't see any pressing question of federal law. What the cases screamed out to me that they're both state law breach of contract cases. And I realize that there's diversity jurisdiction, and I certainly respect that. But the world's not going to come to an end if we remand state court breach of contract cases back to the state courts to decide. We'll probably get a much more accurate reading of state law if we sent those cases back than if we kept them here.
Judge Wilkinson, I have enormous respect for you, and I don't think I've ever respectfully disagreed with you this many times in an argument.
You don't need to respectfully disagree. You can just say you can just say you're crazy.
No, sir. No, sir. I would never do that.
How about the Supreme Court's Thermatron decision emphatically rejects the idea it's no big deal to send state court cases back to state law cases back to state court?
Well, the Thermatron makes that point. Things Decided makes that point. Quackenbush makes that point. The United States Congress has made that point in allowing.
Well, I know, but the question is, this is one of those marginal questions. I mean, the question is whether what happened here involved a procedural defect or whether it didn't qualify as a procedural defect. And so this is not something that's really at the heartland of diversity jurisdiction or whatever. It's not going to mean the end of diversity jurisdiction. All I'm saying is that in these marginal peripheral questions about what is a procedural defect and what is not, I say, well, at the end of the day, having the state courts decide questions of state law is fine, and it's not going to work any strike any fundamental blow to diversity jurisdiction to do that.
Judge Wilkinson, I disagree. This actually goes to the fundamental ability and right to be in a federal forum.
I know you have that. I know that, and I respect that. But what troubles me here is that in reviewing, these questions of remand, here we are up here thrashing around with this question of whether there's a proper remand or there's not a proper remand, and what constitutes a procedural defect and what doesn't, and everything. And none of it has any relationship that I can discern to the actual merits of the case. And the whole idea is to have traffic cop rules work advantageously to litigants by providing clear directions. And what troubles me about this is that legal fees are being run up and litigants are being kept in a degree of uncertainty because we up here thrashing around on the finer points of a question that have nothing to do with the merits of the case. And at the end of the road, there's some people out there that would like an answer of some sort. And yet there's this, in my judgment, the possibility of these enormous detours dealing with appeals of motions to remand. And I'm just wondering whether the interests of justice and systemic justice are not served better by having a strong presumption that remands are not reviewable as a general rule, and that concerns me from the standpoint of the people that, after all, would like an answer from the court system and would appreciate it if their legal fees just didn't run up and if it wasn't delay after delay. And this whole appeal strikes me as somewhat diversionary from the standpoint of resolving cases and giving the litigants some final adjudication of where their rights stand and who's at fault in the breach of contract and what the remedies are. There are a whole lot of questions about who breached the contract and what the remedies should be and what the damages should be. And we're not touching any of them. Not any of them. We're up here thrashing around on whether remand orders are reviewable in these marginal cases.
Chief Judge Diaz, may I respond very?
Certainly.
Judge Wilkinson, the Supreme Court of the United States and Thermtron in 1976 made clear that remand orders like this are reviewable by circuit courts. It's repeatedly upheld that. And there are two different forum selection clauses at issue between the parties. My client's forum selection clause allows it to be in a federal district court. And I would say this is the first circuit court in the country that has had, I know, Judge Wilkinson, you've characterized this as kind of a procedurally, like a procedure geeks unnecessary case that you don't have to address, but this has enormous consequences for every business that operates within this circuit, because there are forum selection clauses. There are ability to avail yourself of diversity jurisdiction to remove a case to get into federal district court. And this has enormous consequences for businesses all throughout the Fourth Circuit.
Yes, but in the vast majority of cases, there are at least somewhat clearer rules about whether the remand is reviewable or whether it's not. But this one's sort of in a foggy middle zone.
Well, I think this court made clear in Ellenberg that a district court sua sponte bringing up a procedural issue is reviewable. So I think, Judge Hudson, he raised this on his own. He was very clear in his remand order.
I think that may be your best argument, but let me ask you about and Judge Hyten's touched on this. Why isn't this allegedly improper consolidation a procedural defect that goes to something else other than subject matter jurisdiction? That's
exactly what this is, Chief Judge Diaz.
I'm asking you.
This is not a procedural defect.
Why isn't it?
Well, at best.
How do you define procedural defect?
Well, the Supreme Court of the United States and this court have never defined what procedural defect is in the context of analyzing a remand decision.
Well, the notice of removal was too late. That would be a
right. So I think in terms of there's no decision, Judge Hyten's, to go back to the case that was just argued where you asked for the specific factors in the case. There's no decision I can give you that says
some obvious ones, like the notice of removal was filed too late. The notice of removal wasn't served on the state court as is required under the Federal Rules of Civil Procedure. The notice of removal does not allege the basis of federal court subject matter jurisdiction. And so I think to answer your question, Judge Diaz, it has to be the procedural defect has to be a defect within Title 28 within sections 1441 to 1453.
because that's the removal provision. We're dealing.
Is that, just to go back, I know I asked you to hold this aside, but like, once it's not subject matter jurisdiction, if we conclude the district court did this sua sponte, none of this matters, right?
Exactly, Judge Heitens. And that's the ultimate point I wanted to get to is because of Ellenberg, Judge Hudson was very clear. He did this sua sponte. So it is reviewable by this court. There's no precedent anywhere that says that the consolidation of a case by a federal district court clerk's office is a defect in the removal process under Title 28 that supports
but
remand.
Even if it is, it doesn't matter. If this was sua sponte, it doesn't even matter if it is, right?
Exactly.
The only thing that matters for sua sponte purposes, the only thing that matters is this plausibly subject matter jurisdiction.
Correct. Okay. And that's the only thing that the district court can raise sua sponte.
All right, thank you, Mr. Lawson.
Yes, sir.
Good afternoon, I think. May it please the court. My name is Courtney Polk, and I represent Colonial Web Contractors Company, the appellee in this matter. Colonial Web filed two separate and distinct state court cases related to two entirely separate projects in the state court. One related to a Michigan project. It involved people in Michigan that worked on the project, certain fact witnesses there. The other, approximately 1,500 miles away in Colorado, related to a different project and an entirely different contract. The
terms of the contract is different.
The refrigeration systems that were going to be put in were very similar, but they were different projects. The contracts are different.
So there could well be differences in damages.
Yes, Your Honor. And different circumstances related to the damages that might arise because the refrigeration systems didn't fail exactly the same.
Yeah.
So the status, importantly, I think the status of the state court cases could have been easily discovered by reviewing the files in the Henrico County Circuit Court, either in person or electronically.
What is your view of the procedural defect? Is the procedural defect in your judgment that a single order of removal was utilized to remove multiple in different cases?
Yes, Your Honor. And the problem with that in this particular
But that's your concern in terms of the procedural defect.
Yes, Your Honor.
And yet, I'm looking at your motion to remand, and although you pointed out this problem, I'm looking at the first page of your motion to remand, I'm looking at the last page of your motion to remand, and I'm looking for you telling the district court why it should remand, and what you say over and over again is a forum selection clause.
With respect to the memorandum in support of the motion to remand?
Yep, looking at it right here.
With respect to the actual motion, it starts with pursuant to 28 USC 1447C, we're asking the court, in addition to the forum selection clause.
So we're going to build up this huge mountain of law on procedural defects. We will get no clear answer to it. It will be, a litigator's field day. And we'll be thrashing around on issues that are traffic cop issues that are collateral to the merits of the case. And meanwhile, you'll be running up fees and the other folks will be running up fees. And it's a lawyer's heaven. But the relationship that it has to the people that brought the suit and would like to have the suit is delayed. Now, the argument against that is that diversity jurisdiction is something that Congress takes seriously. And you don't want district courts saying, well, I just don't want to deal with this case. And so I'm going to remand it. And the Court of Appeals has told me that, that's an unreviewable order, and the Court of those mean people at the Court of Appeals, they can't do anything about it because we've said that the remand orders are essentially unreviewable. And so what you worry about from the other side of the fence here is that we may be authorizing a freewheeling exercise of of abstention on the part of a trial judge who looks at a case and who's kind of mean and going to involve a lot of court resources and everything. I would just remand it, and the Court of Appeals is impotent. And so, is that a realistic fear? Because it is a concern.
What, probably it is a concern, but I don't think that that's what the district court did here.
Really? Because it seems like the district court proceeded to consider whether to remand on a basis that you had never argued it should remand, which is our Ellenberg decision says you're not supposed to do.
I think it's somewhere in the middle, because in all of the cases that relate to judges issuing an order sua sponte that relate to 1447, they only they omit any motion to remand at all. And so I think Ellenberg
it's just very confusing, because if under our precedent, if the district court had actually remanded on the basis you asked the district court to remand on, we 100% would have been able to review it, right?
If on the forum selection
Yes,
clause.
if you said
100%.
you actually, again, I'm looking at your motion, I'm looking at your memorandum. The basis on which you asked the district court to remand was the forum selection clause. And then lo and behold, this court has an on-point published decision that says, if it had done that, we could review it.
And it didn't.
Right.
The
It
court
brought
didn't
up
do
its
that.
own reason for doing this. That was not the reason you asked it to do something.
But the public policy behind the Ellenberg case and Blair and Thermotron is that there was no motion.
No,
to
the public
remand at all.
policy is that with respect to subject matter jurisdiction, which federal courts always have an independent authority to it, obligation to examine. But unless it's subject matter jurisdiction, the public policy is district courts don't try to come up with other reasons to remand that don't implicate subject matter jurisdiction.
But we did hit the
You hit
court
the head
over
on
the
something
head.
that would have been appealable.
We hit the court over the head with the fact that these cases were improperly
But you didn't
consolidated.
ask to remand on that ground. I literally have your entire motion in front of you, and I have you cited the statute. You did not say that's why you should remand.
And at the end, in the relief requested, we say respectfully request enter an order remanding basically for the reasons stated in the motion to
And the
remand.
reasons stated in the motion were the forum selection clause.
I mean, the very first paragraph of the motion to remand says that Colonial Web filed a case in circuit court.
Okay.
And
I mean, I will now read the actual conclusion in your actual thing. In order to deny Colonial Web's motion to remand, comma, the court must determine that Hill Phoenix's terms and conditions control the conduct, and that in turn, Colonial Web's terms and conditions do not apply. Such a conclusion is unsupported. For reasons stated herein, Colonial Web respectfully requests that the court grant the motion to remand.
yeah, and
That does not say one word about improper consolidation.
and I believe that's in our memorandum in support.
What is
Yes,
reading?
yes. But the distinction here, I think the court raised earlier, and I'm not going to recall which judge said that, was this a procedural defect or was it based on subject matter?
No, I'm focusing on
jurisdiction?
the sua spontaneous, which is
So I disagree that this is not colorably based on jurisdiction. And
How?
for this, because
the district court says there is diversity jurisdiction here. I don't know how
Yes.
that's anything clear about
but the
subject matter
case,
jurisdiction.
the case that was attempted to be consolidated or attempted to be removed was omitted in its entirety.
In what conceivable world would that implicate subject matter jurisdiction?
Because the Colorado case wasn't before the court.
Except it is. I'm literally looking at their notice of removal, and it has two docket numbers, one of which is the Colorado case. And the body of the notice of removal refers to the cases and gives both of their docket numbers.
And then the short statement included in the notice of removal does not include any reference at all to the Colorado case. It acts as if it doesn't even exist.
But then it's an argument that the notice of removal doesn't have enough detail. And I think it's Ellenberg, but it may be another case of this court that says failure to provide sufficient detail to establish that there is subject matter jurisdiction is not the same thing as being that there is not subject matter jurisdiction. It's either Ellenberg or another Fourth Circuit case that literally says that exact point.
I believe it's Ellenberg.
Okay. So that's an argument that maybe they needed to include more detail, but Ellenberg says needing to include more detail is not the same thing as there isn't subject matter jurisdiction.
That's what it says. But this court in the Protopappas case said you need to look at what did the circuit or the district court rely on in its order.
Right. And where
the
the district court says that there is subject matter jurisdiction, but there's a consolidation problem. That's what the district court says.
But But the court says in a long paragraph, all the cases cited by the district court relate to jurisdiction. And the court states an action may be removed from state
Whether
court.
whether the district court actually formulated that as a reason for remand, as I understand it, the procedural defect did not just have to relate to the question of consolidation, that's not the only procedural defect that you are contending. I thought you were also contending that there was an additional procedural defect of removing multiple cases with a single order of removal, that just gives rise to all kinds of problems where the multiple cases have very different terms. And as I understand it, that must have been on the district court's mind, and that is what you have identified to me as the defect in the removal procedure, in addition to the questions surrounding consolidation of very different cases. And they are different cases.
And the court didn't make that decision.
Yeah, and the whole idea that, oh, well, you can just consolidate and it's all one case. Well, the case loses its they're still, they remain, you can consolidate them, but they still remain as independent as before.
Well, in the notice of removal, one of the issues is that they don't remain separate because the notice of removal says it's only one case.
But all I'm saying is that I see two problems. One is consolidating two different cases, with trying to consolidate two different cases with different contracts. And secondly, having having this single remand order, moving multiple cases over with a single remand order. I mean, there are two possible procedural defects, and it might be a clear rule to say that it's to avoid all this thrashing around, say that it's not proper to remove more than one case with a single order of removal. And that's a clear rule. And somebody can decide it. And then in the future, somebody won't be up to this kind of trick. Because, these are not the same cases. And yet a single order of removal is trying to remove both.
And the proper process there under Rule 42 would have been to file a motion to consolidate.
Well, do you disagree with Mr. Luff? Let me posit that I agree with you that there is no statute or rule that I'm aware of that says you can remove two cases with a single order of removal. Are you aware of any statute or rule that says you can't?
I think Rule 42 would say because it's up to the court,
right? But
to consolidate.
You say over and over again in your brief that they unilaterally consolidate them, but yet that's not what their notice of removal says. Their notice of removal says we ask the district court to consolidate them, and then the clerk's office actually did it, right? So I don't actually think it's fair to say that they unilaterally consolidated them, because they quite clearly said in the notice of removal, we would like the court to consolidate them, which sounds like asking someone to do something.
But the basis of the reason, my understanding at least, as to why they wanted
right, that's a reason the district court maybe should have denied consolidation. I mean, another way to think about this is take a step back for a second. Everyone agrees these two separate cases are both removable, right? The parties, there's complete diversity.
Yes.
They both involve more than $75,000. No defendant is being sued in their own home state.
Yes.
So these are both removable. So if there's a problem at all, it's that they attempted to shove them together. But that's not a problem about whether these cases can be in federal court. It's whether they can shove them together. So, I mean, among other things, I just think there's a real gap between what the district court thought the problem was and what it did. Because if you really do think this is a problem, I totally get the clerk's office, the district court clerk's office screwed up, deconsolidate those cases. But now they just stay in federal court as two separate cases over which the court clearly has subject matter jurisdiction.
But in that instance, Hill Phoenix could have, the issue was raised through the motion to remand. and other pleadings that were filed within 30 days of the removal. They could have filed another notice of removal. They could have asked to amend their notice of removal.
Or you could have asked the district court to remand on this case within 30 days, which you didn't do.
We did not.
Let me ask you this, and I'm really interested in what your answer will be. If we adopt your rule that there was a procedural defect here, and are we, if we go with you on this, are we doing damage to diversity jurisdiction and the reasons why Congress has authorized the court to exercise jurisdiction in diversity cases? I think early on in the history of the Republic, the diversity jurisdiction really had to do with the fear of home cooking in the state courts. The rationale seems to me to have shifted very slowly. The rationale for diversity jurisdiction seems to me to have shifted very slowly with the time, and it's a little bit less a question of home cooking and a little bit more of the fact that the business community desperately wants a lot of this sort of cases heard in federal court. And so you have to respect the judgment of Congress here, and that those people that say that the diversity jurisdiction is just completely outmoded and then it's a thing of the past. I don't go along with that. It's not my job to decide that at any rate, because Congress hasn't repealed it. But I want you to tell me, and I'm very interested in your answer to this, is if we adopted your rule of procedural defect and said that you simply can't remove in this sort of way, are we doing damage to diversity jurisdiction?
I don't believe so.
Well, you
Your
need
Honor.
to tell me why not.
I think because at the end of the day, we all have rules that we have to follow, and we all have procedures that we have to endure in all court process. And here, to get in one of the cases before the court, it was untimely. And so in that situation, and I believe it was, I'm not going to recall which case it was, but when the notice of removal was untimely, then that was a situation where they couldn't proceed. And so
one of the arguments on your side of the scale is, of course, the fact that we live in a federal system, and that we don't want removal jurisdiction to be denying state courts the right to decide cases involving state law. And so there is in putting some brakes on removal and in having, there is a value, I think, in terms of the way the federal system occupies, is that states, have an important jurisdiction, particularly over questions of state law, and we shouldn't just cavalierly take that away from them without damaging our federal system and the operation of it.
Can I go back to the point you just made that there are rules and everyone has to follow them? Can I ask you about a couple other rules that strike me as actually in the text of the statute that Congress enacted?
yes,
So 28 USC 1447C, a motion to remand the case on the basis of any defect other than subject matter jurisdiction must be made within 30 days of the filing of the notice of removal, right?
yes,
That was a rule that you were required to follow.
yes,
You are also aware that under Thermotron, a district court cannot sua sponte raise anything other than lack of subject matter jurisdiction. That's a rule the district court is required to follow, right?
the Thermotron case
But
did,
the Supreme Court said so?
yes,
Okay, so there's a rule that you have to follow that's in the text of the statute that Congress wrote. There's a rule the district court had to follow that's in a Supreme Court decision. And you agreed with me earlier, there is actually no rule expressly saying you can't use a single notice of removal for multiple cases, right?
there is no rule.
So in other words,
expressly
You're asking us to remand because they didn't follow a rule that is actually not written in any federal statute or rule of civil procedure, and to overlook the fact that it seems to me that your client and the district court both failed to follow rules that are in federal statutes or Supreme Court decisions.
Well, I think in 1447D, what we're asking the court to do, along with the reading 1447D and 1447C in peri materia, that what we're asking the court to do is deny appellate review because the district court's decision was colorably based on in the first argument, that it's based on subject matter jurisdiction. And I understand.
So earlier on, you mentioned these cases. So when I'm now looking at the district court's order. These cases are where the district court is just like laying out the legal principles in the first three paragraphs, right?
So the case in Mulcahy, the court cites Mulcahy twice, and
which says if federal jurisdiction is doubtful or remand is necessary, right?
Yes, and so the courts, this court in Protopopis, I see I'm almost out of time. May I can continue?
Certainly.
The court in Protopopis said that you really need to look in deciding whether or not there's appellate jurisdiction to take a look at we need to look at the order remanding.
I'm looking at the district court saying, although defendant has adequately pled diversity jurisdiction, footnote, and then I go down to the footnote where the district court explains that there's complete diversity and the amount in controversy is more than $75,000. That sounds like the district court concluding there is subject matter jurisdiction.
But I think the use of the word although is important. And it would mean in spite of the cases have been consolidated in error.
In other words, although there is subject matter jurisdiction, the cases have been consolidated in error, which is something that is not subject matter jurisdiction.
I believe that it also could be read that although they've adequately pled diversity, there is not subject matter jurisdiction because all of the cases that I just cited were based on jurisdiction. So it is colorably based on jurisdiction. If it is not colorably based on jurisdiction, then you move to the procedural issue under 1447C. And I believe if the court sua sponte issued an order, all of the precedent relates to cases where there was no motion to remand. I think it is a distinction without a difference because here we did file a motion to remand. The public policy is that we need to signal to the district court that we do not prefer a federal forum.
Can I follow up with that? So it seems to me there are two principles at stake here that sometimes conflict. So first is the fact that federal courts are courts of limited jurisdiction, right? But the counter to that is that if a federal court does have subject matter jurisdiction, it has an unfailing obligation to exercise that jurisdiction. So you seem to be proposing a different rule that anytime there's any doubt about subject matter jurisdiction, given the competing principle of federal courts being ones of limited jurisdiction, district courts should err on the side of not exercising their jurisdiction. But that doesn't seem to me to get it right.
I think really what I'm saying, Your Honor, is that you need to look at the court's order to see what the court based the remand order on. And if it was colorably based on jurisdiction, then 1447D applies and this court doesn't have jurisdiction to hear it. If 1447C applies because it's based on a procedural defect and the case was remanded sua sponte, the court in Ellenberg says that you shouldn't do that, but the public policy in Ellenberg relates to the fact that the court 6 days after the notice of removal just said, we want to send this back. The court in Thermotron said, we have a crowded docket. We just want to send this back. Here, Colonial Web made very clear to the court that we did not prefer a federal forum. And as a result, the public policy in those sua sponte cases does not apply.
All right, thank you, counsel. Thank you both for your arguments. I stand corrected.
Thank you, Judge.
I'm sure I won't be the first time I've done that.
I think if I could, I'll begin, Chief Judge Diaz, with your points and then address the points raised by Judge Heitens. And then Judge Wilkinson, I would like to conclude by address that you're thrashing around comments. subject to any other questions that you have. I think, Chief Judge Diaz, I think you hit the nail on the head. Federal district courts, there is a tension, but they have an unfailing obligation to exercise jurisdiction. Colonial Web just conceded that if both cases had been removed separately, if there were separate notices of removal, Judge Hudson's order is very clear. Although the diversity jurisdiction is satisfied, I'm going to find a fault based on consolidation. And so I think in terms of subject matter jurisdiction, it's clearly satisfied, and it's really not. It
seems like the subject consolidation could never create subject matter jurisdiction. It could only destroy it.
Exactly. And so I think, Judge Heitens, to your questions, the key point here is Judge Hudson raised this whole issue sua sponte. It clearly, Judge Heitens, the JA portions that you read or the portions that we briefed, like it's not, there's no procedural defect in the removal process that was raised in the remand motion. The only issue that was raised was the forum selection.
Well, Congress can't be expected to list all the different things that may be a procedural defect. It used the term procedural defect with the understanding that that it is not setting forth any kind of exclusive list or any kind of list at all. And so the fact that you don't have a procedural defect enumerated as the rule against multiple cases being removed, that doesn't seem to me a bar, because I think Congress left the phrase undefined for a good reason. What concerns me is that if we say that it's not a procedural defect for a single removal order to remove multiple cases, how far does that extend? Here we're dealing with two cases, different states, different contracts, et cetera. But suppose we were dealing with 3 or 4 or 5. I mean, can we have a single removal order that just takes a whole bushel of state cases and moves them over into into federal court? That it seems to me at some point we're getting a very expansive definition of or very expansive operation of removal. And I don't understand. If you reject the rule that a single order is a procedural defect, if you reject that rule, I'm not sure I understand what the limiting principle of your position is.
Well, Your Honor, I think theoretically that could be the rule. Like you could.
Well, how many cases? Answer how many cases? Is 2 cases too many? Is 3 cases too many? Is 4 cases too many?
No, sir. But Judge Wilkinson, that's not the question you have to answer in this appeal, because that was not the basis of the remand order. It was not the basis that did not appear in their motion for.
But it happened.
Yes, sir. It did happen. But
so what are we expected to just ignore the fact that it was an obvious procedural defect? It happened.
Well, Your Honor, it did happen, but it's not a procedural defect under Title 28 of the United States Code, because there's nowhere in Title 28 in the removal provisions that says you have to have a single notice of removal or multiple notices of removal. And what we did.
Well, so are you saying to me that it's okay to have a single order of removal, remove multiple cases into federal court as long as they have some vague similarity?
Possibly, yes, Judge Wilkinson.
Well, it is. It's fine.
I'm sorry?
It's fine for that to happen. We can have a single order of removal and a set of 4 or 5 vaguely related state cases, and we're taking a single order of removal and just moving them on over. Is that okay?
To answer your question directly, possibly yes. But that's not the question you have to answer in this appeal, because what we did in this case, you can limit your decision to the facts of this case. But what we did is we identified both case numbers. We informed the Eastern District of Virginia Clerk's Office that we were told that it appeared that the two case numbers were opened in error because the complaints appeared identical. And if you compare the two complaints next to each other, they are for the most part identical. But again, ultimately, all of that is irrelevant because all the clerk's office did, which is what any good, I mean, that's part of the benefit of being in a federal
the question
district
of
court.
consolidation is all tied up in the clerk's office and deconsolidation and consolidation, but I'm more interested in the limiting principle of how many cases can we just shower on state courts. They're going to feel very happy about it when they not going to be very happy about it when 4 or 5 cases are dumped in their laps. The trial judges in this circuit are not going to be all that thrilled with 4 or 5 state court cases being dumped in their laps with a single order of removal.
Judge Wilkins,
and there are cases out there that say you don't do it this way. And what, are we opening a door?
Judge Wilkinson, I don't think you're opening a door. I think you could write a decision in this case to say there was whether you could have a single notice of removal with multiple cases, or you have to file one notice of removal for each case. You could answer that question if you want, but for the ultimate purposes for how the Supreme Court has directed this court to analyze a remand decision, this was not a decision that was raised by Colonial Webb in their motion to remand. It was a decision that Judge Hudson raised sua sponte. And ultimately, consolidation was irrelevant to the two cases because diversity jurisdiction was satisfied in each. So to go back
to that point, with respect to 5 cases, I don't know that a district court would be any more happy if they had received 5 notices of removal for each of the cases, assuming there was a proper basis for subject matter jurisdiction.
Right. And so, yes, sir. And I think, if anything, I think the clerk's office here should be applauded because they looked at it, and all the consolidation that occurred here was just administrative. Both cases were before Judge Hudson. Colonial Webb, in their briefing, said, we're only going to deal with the facts of one case because the facts of the two cases are essentially the same in their motion for remand. And at the end of the day, there's a very simple clerical remedy, and you just deconsolidate the cases. You have 2 federal.
Well, you don't even have to deconsolidate them. It doesn't seem like there's any obvious reason the district court clerk couldn't have just said, there's a notice of a single document that applies to 2 cases. And I'm going to open 2 case numbers.
Exactly.
And there's a motion to consolidate them and refer that motion to the district court judge.
Right. So for purposes of this court's analysis of whether remand was proper, all of that is a wonderful academic exercise. And it's this is a great law school exam hypothetical in many respects. But Judge Wilkinson, if I may, very quickly, just to conclude, in terms of, I totally hear you when you talk about thrashing around, but I really do want to emphasize this is the kind of case that has enormous and significant consequences for every business that operates within the.
I know that, and I'm not about to adopt any proposition that even hints at the disutility of diversity jurisdiction, because I understand the forces at play in Congress and all the rest, and I respect that entirely, and it simply is not my prerogative to make any comment on diversity jurisdiction. You're absolutely right about the different parties and the different stakes that they have involved. I just understand your point, and I think you made a good argument. I'm just would like. Sometimes there's a value in the law about turning square corners and playing things by the book. And it seems to me that the removal process here was a little sloppy, and it's very unusual that this kind of case would come before us. Normally the cases are more clear cut, than this one, but here the removal procedure was, it was just sloppy. You may well, you may well win, you may well deserve to win, but it could have been done so much better. And it could have, it could have saved you, if you'd done it, if things had been done correctly, it could have saved you an appeal. And it could have saved these folks the expense of defending the remand order. But I just think it was sloppy, and it had worked to the detriment of both parties. You could have spared yourself the need of an appeal. They could have spared themselves the considerable effort that they had to do defending the remand order. I just think sometimes there's a virtue, particularly in these traffic cop situations, of actually playing things precisely and by the book. And I don't think that was done here.
Yes, sir, Judge Wilkinson. The only thing I would add to that is I think this is a good opportunity for this court to give some instruction to federal district court judges on how they are to analyze these things, because I think the Supreme Court has made clear, this court has made clear in Ellenberg, that district courts shouldn't be raising these issues sua sponte, because we never had the opportunity to brief this whole issue before Judge Hudson. So I hear your point, Judge Wilkinson. We're not about trying to delay or obfuscate or play games.
I'm just saying it would save everybody a lot of time, save you time, save these good folks over here time.
Yes, sir.
Both of you save yourselves an awful lot of trouble just by playing it by the book, just by playing, having a separate removal order for each case. Got your subject matter jurisdiction here on diversity grounds. It could have been done right, and you could have had both of these cases in federal court under subject matter jurisdiction, even though the contracts were somewhat different. But it wasn't done that way. And then look what we have here. Do you see what I'm saying?
Judge Wilkinson, I do see what you're saying, but I do want to make sure that, and I very much hear what you're saying. And if I may, I want to be very clear with you and with the panel, McGuire Woods and Hill Phoenix were not trying to play games with the Eastern District of Virginia. That's why, as Judge Heitens has noted, in recognizing the portions of our notice of removal, we endeavored to be incredibly transparent. And we said there are two case numbers. We think they're the same. Here's what we have. And Judge Diaz, I'll just conclude by saying, to your very good point, the clerk's office and Judge Hudson may have also been upset about receiving two notices of removal. So it goes both ways, but I think you can resolve this case and provide guidance to lawyers and to businesses and to district court judges on that issue, Judge Wilkinson. But I do think, if you look at this case, you look at the precedent from this court and from the Supreme Court, the clear remedy is to reverse Judge Hudson and to remand this case back to the Eastern District of Virginia for further proceedings, including resolution of the pending motion to dismiss.
All right. Thank you, Mr. Lofton.
Thank you, sir.
Case is submitted. I'll ask the clerk to adjourn court. We'll come down and greet counsel, and then we'll resume the bench for Q&A.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.
Good to see you. It's nice to have you here. What a pleasure.
Always good to see you.
Yeah, thank you for your argument.
You're welcome. Thanks.
Appreciate it. Come on up. Come on up. How you doing today?
I'm great. How are you?
It's good to see you. It's a pleasure to see you.
All right, please be seated.
afternoon. For those who don't know me, I'm Leslie Kendrick. I'm the dean of the law school. And I first want to say, judges, thank you so much for joining us here today. We know it's considerable effort on your part to take your show on the road and to hold court here with us today at the law school. And we are very, very grateful. I remember seeing the Fourth Circuit sit in the same auditorium when I was a law student, and I can personally attest to the impact that it can have on students to see the court in action. So I hope that you'll give us leave to just thank you with a round of applause. Oh, absolutely. Oh, thank you. Is that better? Good. Yes. So the judges have graciously agreed to do a few minutes of Q&A with us. And we have a microphone and Laurel, who's graciously agreed to help to get to you with your questions. So while you all are thinking of questions, and I encourage you to ask a question, I'll ask one to get us started. But please do raise your hand and ask questions. So judges, and maybe Chief Judge Diaz, we're very fortunate not just to have the panel, but to have the Chief Judge of the Fourth Circuit here with us, Judge Diaz. So as Chief, maybe I'm directing this question to you. Everyone who saw one of the three arguments today saw you all come down from the bench and greet and shake hands with all of the counsel that were at the tables. And not every circuit does that. Could you talk a little bit about that tradition and why the Fourth Circuit thinks it's important?